Not every M&A deal reaches the finish line. In Vietnam, many promising transactions fall apart due to avoidable legal, regulatory, or commercial mistakes. These deal killers can waste months of negotiation, damage reputations, and block future opportunities. In this video, we break down the top reasons M&A deals collapse in Vietnam, and more importantly, how to avoid them. One of the most common deal killers is inadequate legal due diligence. Investors fail to uncover critical issues such as unpaid capital, missing licenses, labor violations, or undisclosed liabilities. These issues surface late in the process and create mistrust or force costly renegotiations. The solution is early, detailed, and locally adapted legal due diligence that goes beyond document review to identify real risks. In Vietnam, many M&A transactions require approval from investment authorities, competition regulators, or sector-specific ministries. Buyers who overlook these steps may face rejection, delay, or legal invalidation of the share transfer. Deals collapse when parties cannot align on how to obtain or time these approvals. The fix is to map out all required filings from the start and build them into the transaction timeline. Vietnam imposes foreign ownership caps in various sectors. When a foreign buyer seeks majority control in a restricted industry, the deal hits a wall unless properly structured. Some try to bypass the law through nominee arrangements, which are legally risky. Deals collapse when parties discover too late that the desired structure is not permitted. The solution is to confirm foreign ownership rules early and explore compliant alternatives. Ambiguity or imbalance in the share purchase agreement can also derail deals. Examples include unclear pricing mechanisms, unrealistic closing conditions, weak indemnity clauses, or lack of remedies. If the agreement does not reflect the commercial intent or fails to protect both sides fairly, negotiations break down. The answer is to work with experienced counsel to draft precise, Vietnam-ready contracts. Sometimes the buyer expects to take over full control, while the seller wants to remain involved. Disputes over future roles, employment terms, or revenue sharing can kill deals. The solution is to clearly define post-deal roles, board composition, reserved matters, and exit rights in advance. Clarity avoids resentment and legal conflict after signing. Buyers are often surprised to find that key assets are subject to third-party rights. This includes leases without assignability, joint ventures with change of control clauses, or IP registered under personal names. These hidden rights can block integration or trigger contract terminations. Early identification and negotiation with third parties is essential to keep the deal intact. Tax liabilities, transfer pricing issues, and financial misstatements can spook buyers or force last-minute price reductions. If the seller refuses to indemnify or escrow funds for these risks, the buyer may walk away. The best defense is comprehensive tax due diligence and protective clauses in the SPA, including tax indemnities and holdbacks. Even legally sound deals fall apart when communication breaks down. Delays in providing information, inconsistent messaging, or surprise disclosures can damage trust. In cross-border deals, cultural misunderstandings or language gaps increase this risk. The solution is proactive communication, use of bilingual advisors, and clear coordination throughout the process. Some deals collapse because one party sets an unrealistic deadline or the buyer cannot secure funding on time. In Vietnam, regulatory procedures take time and banking controls affect payment flows. Flexibility in deal timing and proper planning for capital movement are crucial. Parties must align on realistic closing dates and interim conditions. Unexpected findings during final review, such as hidden litigation, non-compliant land use, or expired permits, can cause buyers to pull out. These are often the result of incomplete due diligence or lack of transparency from the seller. The key is to front-load legal review and require full document disclosure early in the process. At LTS Law, we help clients avoid deal killers by taking a proactive, end-to-end approach. We identify red flags early, structure deals for legal compliance, guide regulatory filings, and draft protective contracts. Our role is not only to close the deal but to keep it clean and durable. We work across sectors, borders, and legal systems to ensure deals get done the right way. Don't let avoidable mistakes sabotage your M&A plans in Vietnam. Let LTS Law protect your investment with smart legal strategy from day one. Visit lts.com.vn to schedule a consultation. Deals fail for many reasons, but with the right legal partner, yours won't.